Mr. Mesereau?
Thank you, Your Honor. Ladies and gentlemen, I have 2 more instructions to show you. I can't show you every one, they're pretty voluminous, but I'd like you to just give careful consideration to these particular instructions, particularly this witness willfully false instruction. It says, a witness who is willfully false in one material part of his or her testimony is to be distrusted in others. You may reject the whole testimony of a witness who willfully has testified falsely as to a material point unless, from all the evidence, you believe the probability of truth favors his or her testimony in other particulars. And when you go into the jury room and talk about the arvisos, please give careful consideration to this instruction. This is the last one I'm going to point out. It says, association alone does not prove membership in a conspiracy. Evidence that a person was in the company of, or associated with, one or more other persons alleged or proved to have been members of a conspiracy is not, in itself, sufficient to prove that person was a member of the alleged conspiracy. So when the prosecutor gets up and tries to tell you that somehow knowing Mark Schaffel or knowing Konitzer or Dieter is proof that Michael Jackson engineered, remember, they're saying he engineered a criminal conspiracy as a response to the Bashir documentary. If they try and suggest that through documents showing people are in business together, or associated together, or might be seen together, that's not proof. They have to prove beyond a reasonable doubt that Michael Jackson, 1. specifically intended to form an agreement to conspire, and, 2. wanted to falsely prison, abduct kids, or commit extortion. And it's nonsense. Now, ladies and gentlemen, the prosecution claims that Mr. Jackson had a response to the Bashir documentary, and the response was to commit crimes. And the prosecutor wants you to think that after February 20th, through all those interviews, that somehow molestation began. And now I want to show you what was available at the time. Input 4, please, Your Honor. Whereupon, portions of DVDs, People's Exhibit 2 and Defendant's Exhibits 5000A, B and C, were played for the court and jury. Ladies and gentlemen, this has been a nightmare for Mr. Jackson. He has been lax with his money. He has let the wrong people sometimes associate around him. He was naive to allow the arvisos anywhere near him. But under the law and the facts in this courtroom, you must return a verdict of not guilty on all counts. It's the only right verdict. Thank you.
Thank you, Mr. Mesereau. Mr. Zonen, did you need a couple of minutes to set up?
Just a minute, Your Honor. Yes, please, Leslie? I'm going to use that one.
I don't need a minute.
Your Honor, an hour and 14 minutes?
1/14.
1/14, thank you. Can we go back to Input 1, Your Honor? Ladies and gentlemen, good morning. This responding argument is going to be in response to the argument delivered by Mr. Mesereau over the last 4 hours of court time, and it will be limited to those issues that he has presented. I would like to begin by talking to you about a statement that had been projected up on the board by Mr. Mesereau yesterday, and that statement that had been projected up on the board referred to this comment. He said, "Prosecutor," he was quoting a prosecutor. He said, "A prosecutor said that it was like a band-aid for a bad case." What he was referring to, of course, was the propensity evidence that had been presented by the prosecution. The propensity evidence was the evidence of all of the witnesses who testified to the 1993 investigation. That, of course, included the testimony of June Chandler, and Jason Francia, and Jason Francia's mother, and the other people who had previously been employed at Neverland. That statement, prosecutor said, like a band-aid for a bad case. Let me suggest that that probably was not said. Let me suggest that that's not the first time that Mr. Mesereau has referred to a prosecutor who has made a quote improperly. Let me remind you of the time that Mr. Mesereau was cross-examining Dr. Katz and kept referring to a statement from a prosecutor in a book that Mr. Katz had written, until we finally asked to see the book and discovered that the real word was lawyer. Now, that statement would make more sense if it was in fact lawyer. A lawyer said that this is like a band-aid for a bad case, because no prosecutor will ever stand up here and tell you that giving too much information to a jury is bad. In fact, in this particular case, it's highly appropriate. The information about the use of propensity evidence is what gives you a clear and concise understanding about the type of people who commit these types of crimes. Let me read something to you. By their very nature, sex crimes are usually committed in seclusion, without third-party witnesses or substantial corroborating evidence. The need for this evidence is critical, given the serious and secretive nature of sex crimes, and the often resulting credibility contest at trial. The willingness to commit sexual offenses is not common to most individuals. Thus, evidence of any prior sexual offense is particularly probative and necessary for determining the credibility of the witness. What I've been quoting to you is the legislative text that accompanied the enactment of that statute that allows us to be able to bring in evidence of prior sexual misconduct by the defendant charged with a child molestation. Why? Because these types of crimes take place in private. They don't take place in public. And in this particular case, we're talking about the privacy of literally a fortress, behind multiple locked doors, and multiple alarm systems, where the defendant, after much effort, after much seduction, after much grooming, has the advantage of having a child in his room, and not the first one, in this case for long periods of time, subject to the intimacy that he dictates. And that's why it's so important so that a jury is not left with the belief, why, at age 45, does this man suddenly act out with a 13-year-old child? And when you see the total picture, you realize it was anything but suddenly acting out with a 13-year-old child. Now, look at the evidence that was presented even by the defense in the course of this case. Think about the testimony of Mr. Barnes, Brett Barnes, who, while on the witness stand, was extraordinarily evasive on the question of, tell me how much time you actually spent with Michael Jackson. Was it one night? Was it 2 nights? Was it a week? And his answer was, really don't recall. I can't recall when it was. Some nights it was here, some nights it was there. He just did not answer the question. And when his mother was on the witness stand, she wouldn't answer that question either. Sometimes he stayed with us. Sometimes we were traveling. Sometimes he would be with Mr. Jackson. And again, very evasive in terms of committing to any kind of detail about Brett Barnes' relationship with Michael Jackson. Not until his sister was on the witness stand, and not until cross-examination by Mr. Auchincloss, when all of a sudden he started asking her, in all her jubilance. She was an excited witness up there, very happy, filled with glee and a big smile, and very happy to be here on behalf of Mr. Jackson, until Mr. Auchincloss started asking questions. Tell us how long we're talking about. What period of time exactly was it that your brother was in the accompaniment of Mr. Jackson and specifically in his room? And suddenly it came out. She says, a year. She said it in terms of, there was a 6-month tour and another 6-month tour. It was the entirety of those 2 combined tours, which meant over 1 year. And it was like a ton of bricks landed in the middle of the floor. All of a sudden, everybody got it. All of a sudden everybody is sitting and thinking, 1 year, 1 continuous year this child, who at the time was either 11 to 12, or 12 to 13 years old, was sleeping in Mr. Jackson's bedroom continuously. This man has never had adult companionship to that extent that any of us have heard of at any stage during the testimony in this case. 1 consecutive year. This man went to bed every night with a 12-year-old boy the entire time. As they traveled from one European capital to another, as they traveled from one South American capital to another, as they ventured even into Africa. And it was confirmed by a second witness called by the defense, when James Van Norman, the security chief at that time, was called as a witness and testified entirely on direct examination without any reference whatsoever to Brett Barnes. And then on cross-examination by Mr. Snedden was asked exactly the same question. And he also acknowledged exactly the same thing. That witness had the nerve to sit on the witness stand and tell you that nothing improper happened at Neverland while he was head of security there. And then on cross-examination acknowledged to you that at the end of each day, this child, maybe 12 years old, went into Mr. Jackson's hotel room, each hotel room throughout Europe and South America, went into his bedroom and stayed there. He was his constant and continuous companion for the better part of 12 months. That is not a friendship. That's a relationship. Mr. Jackson loved that child not as one loves a child, but as one loves a companion, an adult, a sexual relationship. It's the only explanation for that. In your entire lifetime, you have never heard of another middle-aged man doing that with a child. In your entire lifetime you never will hear of another middle-aged man doing that with a child. You would be outraged if you were to find out that there was somebody who lived in your neighborhood who was taking young boys into his bedroom amidst a sea of pornography and alcohol. You'd be on the phone with the police in a second. And yet in this case, we're expected to say that that is normal. It is loving, it is kind, it is nurturing, and it is non-sexual. Why is that? How exactly was he non-sexual with this child in his bed for over a year? Over a year. Are we expected to believe that he's simply non-sexual? When we look at the collection of materials that he has in his house, in his own home, and the distinction between the thousands of books that Mr. Mesereau was talking about is the fact that, which was 1,000,000 books in his opening statement. It's now down to thousands of books, and it's probably substantially less than that, and frankly, probably came with the house. Most of the books depicted in the video that he showed you looked like they've never been opened. But as to those books, they're in a library. As to the books that we seized, they're in his bedroom. And that included the entire collection of homoerotic material, some of which was so extreme in its nature we simply couldn't open that book in this courtroom. But what, then, do we say about him? How do you explain that? How do you explain child after child after child? Mr. Robson, for an extended period of time as a child, was in his bed going back to age 7. Think about your children when they were 7 years old, what they looked like and how big they were. 8 years old. He was in his bedroom. Not just bedroom, but in his bed. Macaulay Culkin, he flew across the country to spend a week with Macaulay Culkin alone. Where is the adult companionship in this case? Where has he ever had that kind of trip to be with an adult, a special relationship? No words about that at all in the course of this trial. Nothing. It is because we have heard that testimony that we have an understanding of Michael Jackson that we never would have had that testimony not been presented to you in the first place. So let me suggest to you that the testimony of Brett Barnes, particularly his sister, Wade Robson, Macaulay Culkin, who spent an entire vacation with Michael Jackson, who invited himself so he could be there with an 11-year-old boy. And then June Chandler, who was described in Mr. Mesereau's closing argument as a gold digger, and of course was a quote from Joy Robson. Joy Robson, who received over $20,000 from Mr. Jackson, a car, immigration to the United States, and a job, as well as an apartment, describes her, June Chandler, as a gold digger. June Chandler said in her testimony, about an event that took place in New York, that Mr. Jackson was so upset and so angry during the course of their being in New York, because she was protesting the fact that Jordy Chandler was spending all of his time with her, a statement that was shared with Joy Robson in her deposition 10 years ago in the Jordy Chandler lawsuit. He simply grabs up the time of whichever child he is with. He broke a lamp. He tried to get Lily to say that it was broken by accident. He was crying. He was upset. He was pleading with her to allow him to have access to her son, Jordy Chandler. He slept with Jordy Chandler for well over a month, closer to 2, and particularly, and this was in his own home, in his own bedroom, in his own room, between the times that he would come from school and go to school during that period of time. What kind of answer is there to that? How do you possibly come to grasp with that kind of information except to conclude that they had a relationship? He was in love with that child. In love with that child the way that an adult would fall in love with another person, and it wasn't the only child. And it was happening with Gavin during this period of time. Gavin went right into it. It began with long phone calls, long periods of conversations in the middle of the night. They'd go for hours. It began with him coming to Neverland. It was the same kind of run around and do anything you want on Neverland and end up in his room from the very beginning. Understand something about Mr. Jackson and his relationship with his family and his relationship with Gavin Arvizo. On the 2nd of March, while he was there, on the 2nd of March while he was in Florida with his family, he came back to Santa Barbara, leaving the family behind. And who happened to be back at Neverland on the 2nd of March? Was exactly the day that Gavin and his brother and sister and mother returned back to Neverland. And at that point the boys returned back into his room, and eventually Star left that room. And during that period of time they stayed there forever, until they finally left at Janet Arvizo's behest on the 12th of March. Exactly the same kind of relationship that he had with Jordy Chandler. Exactly the same kind of relationship he had with Brett Barnes. It simply didn't go long enough because his mother had the sense and foresight to get them out of there. A couple issues dealing with the jury instructions. There was an instruction that was read to you. It was the very, very first instruction that was read to you, and it's one that's probably worth reading again. I'm not going to read it to you, I'm just going to tell you. It is an instruction that says that you are not to consider sympathy, pity, punishment or consequences of the crime in your deliberations in this case. You cannot consider what will happen, what won't happen, and you can't sit back and say, I feel sympathy for or against the defendant in this case. You can't be sympathetic on behalf of the victims. You can't be sympathetic on behalf of the defendant. You simply have to judge the evidence dispassionately and impartially. Counsel has talked repeatedly about the question of why aren't the co-defendants, the unindicted co-defendants, included in here. There is an instruction that was read to you. You are not to consider that either. Those are two instructions that Mr. Mesereau violated within the first half hour of his closing argument. You cannot consider the question of whether others were included or not included, will be included, won't be included. That is simply not part of your deliberation process. You're to decide this case singularly. I would think Mr. Mesereau would be happy after 4 months of trial, over 4 months of trial, not to have dealt with 5 more lawyers in this courtroom, frankly. The J.C. Penney litigation that took place, let me suggest, I'm not going to go over this at length, but let me suggest to you that that was a case that was in no way fraudulent based on the evidence that's before you and reasonably resolved by everybody. Janet Arvizo was never in that store. She had nothing to do with that theft. She went out and she came from a different place where she was applying for a job. She saw an altercation involving her husband. She went to his rescue. She got beat up. Not horribly, but got beat up. Had bruises up and down her legs, up and down her arms. Those photographs were not taken weeks later. Those were taken days later, as black and blue marks do tend to surface days later. Those injuries that she had were reflective of the kinds of restraint that she was subjected to with her being down on the ground and people on top of her legs, people on top of her arms, so that both, the arms on both sides and legs on both sides were subjected to those kinds of contusions. She did go to jail. She was there for less than 2 hours. She did not make a claim of injuries at that time. Those are not the kind of injuries that would surface initially. They're black and blue contusions. They would come up later. She had no interest in staying in jail, as would anybody have any interest in staying in jail. Did not make any claims. Was out of jail in 1 hour and 45 minutes. And within 1 hour and 6 minutes after her husband was released from jail, she went into the clinic. Now, we're supposed to believe that it was during that period of time that her husband beat her up. That he would beat her up on the front of her legs, the front of her arms, the back of her legs, the back of her arms in that period of time, and then take her to a clinic. Let me suggest to you that in the history of the world, no batterer has ever beat up his wife and then rushed her to a clinic. That is a one-way ticket to jail. Because the first thing they do is ask what happened and how did it happen. And those injuries were not that bad that he would have been compelled to take her during that time. Mary Holzer not only said that Janet Arvizo said that that's what happened, but Mary Holzer said that the kids were there, and the kids were injured in like fashion. We know that didn't happen. Excuse me. We know that both children stayed at the scene at the time of the arrest of the father, in the presence of the mother, until the grandmother got there, Maria Ventura. When she got there, the father was already in custody and had been taken away. The police were there and had been there for the entire time. She took the children and took them home. The kids complained of pain. Starr complained of pain to his head, and in fact he had a concussion. Gavin complained of pain to his arm, and in fact he had a fracture in his elbow. They had not had any contact with their father at all. It wasn't until the next day that they went to the hospital by the parents, were taken, and the injuries were diagnosed. Mr. Mesereau said that Janet Arvizo complained that the cyst that was discovered in Gavin's head she credited to the beating that occurred at J.C. Penney's. No, she never did. She never said that at all. What she said was it was discovered at that time when they were trying to determine the cause of the headaches that he had. They discovered he had a cyst, benign, and hopefully will remain that way. There was a lawsuit at that time. There was a deposition that was taken at that time. She did lie in that deposition. About what? She said she was not a victim of violence at home. She was still living with him. What is she going to do? Say otherwise? The kids also were asked that question. Mr. Mesereau is mystified that they would say that they were not coached to lie. No, they weren't coached to lie. They don't have to do that. Children in a violent household intuitively know not to discuss that sort of thing. That is just not discussed. There was no lying in that regard. Yes, it's true, she said she was not a victim of domestic violence. That's pretty understandable under the circumstances. She said she had asked the law firm to change it later. Now, the question of whether or not, given that period of time, could her husband have inflicted those injuries on her, and on the children, who were not even in his presence, does that necessarily mean, then, that there was a fraudulent lawsuit? And the answer is, there was no fraudulent lawsuit, notwithstanding Mary Holzer's desire to be a witness in this case. And as evidence of that is the fact that the lawyers that she works for have kept the money that they got, all $85,000 of it. They've known about her accusations for some time, and they haven't seen fit to return that money. Nor has J.C. Penney's seen fit to go after it. So everybody seems to think that this was an entirely reasonable resolution of this case, for being beaten up and for being falsely arrested and falsely charged, until ultimately the charges were dismissed. She got $32,000. That is not unreasonable. Gavin had a fractured arm, and he got $25,000. It's sitting in a bank account. Starr had a concussion. He got $5,000. It's sitting in a bank account for when he turns 18. And the father, David, got $5,000, approximately. I don't know what he did with his, nor do I care. That comes to about $65,000 total. The balance of $85,000 went to the law firm. They've kept it. The resolution of that case was fair. It was appropriate. The disposition was appropriate. Lawyers. There was a lot of discussion about Janet Arvizo going to lawyers and having had many lawyers. She had a lawyer who represented her in J.C. Penney's. She had a lawyer who represented her in the J.C. Penney's case. She had a lawyer who represented her in her divorce and family law matter. And after she stayed at Neverland for that period of time and finally got out, she went to see a lawyer by the name of Mr. Dickerman. She went to see Bill Dickerman after being told by two different people, "You need to go see a lawyer." One of them was Asha Pryor, who testified to that in court during the course of this trial. The other one was Jamie Masada, and he was the one who suggested Bill Dickerman, who was his personal lawyer. She went to Bill Dickerman. And what did he do? He made demands for the return of all of her property, 2.5 months of demands, without being told where the property was and without having any of it returned. And he made demands that the kids be taken off television through Granada Productions. In other words, his pursuit was in two directions, and he at no time filed any kind of a lawsuit against Michael Jackson. How did the family get to Larry Feldman, was Mr. Mesereau asked. Well, the answer to that question is Bill Dickerman took them to Larry Feldman, because he knew that Michael Jackson was involved in all of this, and he was not about to take on Michael Jackson and his minion of lawyers. As you recall, Michael Jackson pays $4 million a year in legal fees. He has plenty of lawyers. Bill Dickerman, who was a sole practitioner, was not about to take on Michael Jackson by himself. He knew that Larry Feldman had taken on Michael Jackson in the past, and he went to Larry Feldman. Larry Feldman is senior counsel in a 600-lawyer law firm. 600 lawyers is exactly the opposite of Bill Dickerman as a sole practitioner. Larry Feldman sees this family walk in the door, and he looks at Jordy Chandler. He looks at Gavin Arvizo, who is literally a Jordy Chandler clone, like these other boys, and he takes a look at him, and he immediately sends the family to Stan Katz, Dr. Katz. Mr. Mesereau described Katz as Larry Feldman's good friend, Dr. Katz. In fact, the evidence is exactly the opposite. Stan Katz has worked with Mr. Feldman on one other case, and that was the Chandler case, and that was 10 years earlier. And in his 25-plus years has never worked on any other matter with Larry Feldman, has never been to his home. Feldman's never been to Katz's home. They know to say hello to one another when they meet one another in court or in other places. But they certainly are not close friends or even friends at all. They are simply acquaintances and associates in terms of professional associates. That statement was designed to cast some aspersion upon the both of them that they're in league together. And in fact, there's no evidence of either one of those. Stan Katz interviewed the children, interviewed the mother, interviewed the sister, and decided that this matter needed to be reported to Child Protective Services, and did so. From there, it went to the sheriff's office in Santa Barbara. There was no disclosure by Gavin at any time to anybody until he did so to the police, when he sat in an interview. And you watched that interview, and you're going to watch a portion of it before we leave. That disclosure did not, or at any time has Gavin varied in the contents of the description of what happened to him. And the only extent of the variance that Mr. Mesereau was able to talk about is the timing. And now we're going to talk about the timing a little bit, because I think that is appropriate for you to understand. The question posed by Mr. Mesereau is, why would he do it then? Why would he begin a molestation just after this child has been interviewed about exactly that? Why would he do it after the publication of this thing on television? Why would he do it after he spends time in this video presentation? The answer simply is, because he could. It's really not much more complicated than that. Because he has no restraints on his impulses. Because he had been working with this child for some time. Because this child had been in his bed for some time. And it may not have begun after the video was produced. Gavin testified to you that he had a recollection of 2 specific events. He believed it happened after the video was produced, and that would mean after the interview with the Department of Child and Family Services simply because they are closely aligned. He went from one to the next. And at some time after that, which would have been on the 20th of February and sometime thereafter, before the time he left. He also said, and has consistently said, he thought it was closer to the time when he actually left. And that would be consistent, too. Why would Mr. Jackson do it? Because he could. Because he had this child in his room. Because he had been working with this child for some time. Because this child was in love with him. Because this child would do anything that he wanted him to do. Because this child was already in his bed and already sharing the intimacies of his affection. Because this child already was viewing the pornographic materials that were there. Because this child was already freely drinking. Because Star had started leaving the room and was no longer there at that particular time. And his opportunity was there and the child was ripe. And Mr. Jackson frankly was completely indifferent to the question of whether or not this was in close proximity to a televised production of one nature or another. In fact, he was more confident because he knew that by virtue of the fact that this child had gone on tape saying nothing had happened, that he was probably pretty safe at exactly that moment. When did the molestations begin? We don't know. We don't know. The best estimate was at some time after the meeting with the Department of Child and Family Services. Certainly could have been before. Gavin initially said he had been molested 5 times. By the time he got before the grand jury, which was some number of months later, his testimony was, I remember 2 in specific particularly I can give you details of. There may have been more. There probably were more. I just can't give you the kinds of details. We were drinking a lot during that period of time. A 13-year-old boy. Now, Dr. Esplin was quoted yesterday in one of the displays by Mr. Mesereau as saying something to the effect that there are many allegations, false allegations, that are motivated or spurred by profit. I didn't remember Dr. Esplin saying that. And I can, and certainly Dr. Katz did not say that. And Dr. Urquiza did not say that. In fact, both of them said that there was no recollection whatsoever of any event. They just were unfamiliar with any occasion at all involving an adolescent boy who had been molested and that, or, rather, an adolescent boy making a false accusation of molestation for purposes of financial gain. Neither one of them had any recollection of any case like that at all. So when I hear or when I see Dr. Esplin being quoted as saying, yes, that's a common feature, I went back to his testimony to see exactly what it was. This is a question by Mr. Sanger. And would financial gain be a potential motive for, on the part of the influential adult? And his answer was, could be. Could be. Suddenly, being told, could be, that there could be a financial motive on the part of the influential parent, has translated to multiple accusations of false accusations of child molest motivated by finances. As you can see, his testimony in this regard was nothing akin to what was presented to you yesterday. None of these doctors who testified, 3 of them, 2 for the prosecution, 1 for the defense, not one of them stood up and told you that this is a common occurrence at all. And in fact, all 3 of them told you that adolescent boys making accusations of being molested at the hands of an adult male is probably the single most difficult accusation for a child to make in terms of disclosure of molestation. That is the toughest, because no other victim endures the hardships of wondering whether they're going to be tormented at any particular time. Now, one of the pieces of information that was said to you by Mr. Mesereau in his closing argument was the fact that Gavin had twice been interviewed by Dean Alpert and had not disclosed the molestation to him. Keep in mind that all of the experts who had testified, including the defense expert, Dr. Esplin, said, these are very difficult disclosures, and piecemeal disclosures are not unusual and in no way bear on the validity or integrity of the disclosure in any way. But let's look particularly at that statement of not disclosing to Dean Alpert. Gavin Arvizo was in Dean Alpert's office because he was acting out. Okay? He was acting out because he was being tormented by other kids in the school, and he was being tormented because they were accusing him of having had some kind of sexual connection with Michael Jackson. He was a 13-year-old boy in middle school. And he was getting in fights because of those accusations. And kids were teasing him about it. And suddenly he finds himself in a principal's office or a dean's office, someone with no ability whatsoever to be able to deal with this kind of situation, who simply says, "Is it true?" And he says, "No, it's not true." Would any 13-year-old boy that you know say anything other than that under those circumstances? That, my friends, is not a reflection of his integrity in any way whatsoever. Nor is it a reflection on whether or not his ultimate testimony here is anything but completely truthful. It's a 13-year-old boy out there alone, by himself, harboring this horrible secret about what had happened to him, having been outed, effectively, by this nationally televised production, who is now trying to protect himself as best he can. You can't conclude anything from that at all. Dr. Katz said, "In addition to all the cases that I've seen, I've supervised numerous interns and other professionals. I don't recall seeing any adolescents or pre-adolescents who are making allegations to profit." Mr. Mesereau told you yesterday that he said that Mr. Katz, Dr. Katz, had said to you that he had never seen a false accusation of sexual assault, of child molestation. In fact, Dr. Katz said nothing of the kind. He said that there are many false accusations when children are very, very young, often pre-verbal, and those accusations are usually in conjunction with a divorce proceeding where one parent wants to keep the child away from the other parent. He says, as children get older, those instances reduce substantially. He says he had some familiarity with teenagers who made false accusations. He said they were all girls attempting to get out of a household situation. In other words, a parent that they did not want to be living with. Those circumstances that he believed to be false. He said he had no familiarity at all involving an adolescent boy who had made a false accusation. And particularly an adolescent boy who had made a false accusation motivated by profit. The suggestion that you can tell a 13-year-old boy, "You need to humiliate yourself. You need to stand up and give testimony," that's going to be demeaning. It's going to be tormenting. You're going to be in front of a room full of people. You're going to be harassed by your friends. You're going to be tormented by a defense attorney. You're going to be cross-examined at length. But don't worry, we will be rich some years down the line. A 13-year-old boy? Not likely. And not given what we know about Mr. Jackson and what we know about his history. Excuse me. Mr. Mesereau said that Gavin Arvizo had told you that he was touched right after the Miami trip. No, he didn't. He never said that at all. That is not part of the testimony. And you will not be able to find that in the transcript anyway. He never said that. His statements about when this happened were all fairly consistent in terms of being toward the end of his stay at Neverland, which covered about a 5-week period of time. There was a lot of commentary by Mr. Mesereau about the bad conduct of the children while they were, not just while they were at Neverland, but also Gavin's conduct while he was a child at John Burroughs Middle School, and it was documented and there was a lot of evidence and the teacher talked to that. It went on for hours in terms of, were you acting out? Were you getting in fights? Were you talking in class? Were you singing in class? There's really not anything that's all that bad. It showed a child who was disrespectful to a teacher, and a child who was acting out. Let's begin this discussion with my saying something about his testimony, what he told you. Gavin today is an honor student. He's an honor student at his high school. He plays on the football team. He is a graduate of 3 years of military cadet training, which is the equivalent of scouting. 3 years he's been doing that. All of you who have children who have been in scouting, I think you understand the commitment that a child makes to stay in scouting for 3 years, and the progress that they make as they go along through 3 years of scouting. And I think that you see, for those of you who have children or who have been in scouting or know children who have been in scouting, the change and the transformation that takes place with a child who stays committed to that kind of a program over that long a period.
Objection.
Sustained.
Let me suggest to you that the child that you see testifying here today, or over this trial, who is a child who is an accomplished, a child who is an honor student, and a child who's doing entirely.
Objection.
This is not inappropriate. This is in evidence.
It's not.
Gavin testified to it.
Overruled. You may proceed.
That the testimony, when Gavin told you about his state of affairs today, means a decent and a quality of life, a good child. What is consistent in his life and what is inconsistent in his life today? He no longer has David Arvizo in his life, and he no longer has Michael Jackson in his life. And Jay Jackson's in his life. And today he's thriving. So now let's talk about what happened back at Neverland and what was going on even before Neverland. At Neverland, the accusation as to Gavin, both Gavin and Star, that they were stealing, that they were drinking, that they were misbehaving, that they were cursing, that they were behaving inappropriately with other people, that they were sexually inappropriate, at one point that they were caught masturbating, at one point they were caught in possession of sexually explicit materials, that Star at one point threatened somebody with a knife. Incidentally, both of those people who talked about that incident said it was a joke, that they never took it seriously. They understood it to be a joke. That Gavin used to like to cook in the, Star used to like to cook in the kitchen. Neither one of them took it seriously. All of those accusations that were made about the boys. Let me also tell you that virtually all of the witnesses who testified to their bad conduct also said that they were quite well behaved at the beginning, or certainly better behaved, and got worse as time went on. 5 weeks. 5 weeks of a lack of discipline certainly would explain it. Before I get into too much of a discussion about this issue, let me say something that would govern, the whole question of whether or not these allegations are true or not true. Let me start with one basic observation. Any adolescent male, any adolescent boy in America, delivered at Neverland and left to Mr. Jackson's agenda, will eventually do just about every single thing that these two boys have been accused of doing. Doesn't matter how good of a child initially. Doesn't matter how good the family is. It doesn't matter how good the parents are. The most religious, the most conservative, the kindest, the best parents. You take that child away from his parents, and you subject him to the ordeal that is Neverland. Play all day. Do anything you want. No discipline, no school, no homework. Eat whatever you want. Do whatever you want. Pornography and alcohol. Stay up all day, up all night. Sleep when you want. Do what you want. It will not take long before any adolescent boy in America would ultimately end up doing any of those things. So I begin that comment to you because I want to be able to say, as I sit here and talk about some of these things, that I'm not going to put myself in a situation of saying, this didn't happen. This did happen. This didn't happen. We don't know. But let me say, just as an observation on the testimony of those witnesses, nobody ever wrote that stuff down. There is not a log anywhere that reflects any of the things that they're accused of doing, including driving an SUV. There is no observation of any single person who came into this court and testified that they ever saw Gavin or Star, these 12 and 13-year-old kids, who are barely 5 feet tall, if that much, driving a Navigator around this property. And they now say that was the reason for a sign that said, "Don't let them leave the property." How about a notation that says, "Don't let them get in the SUV"? Or even better, deliver them back to their home in East Los Angeles. The notion that these kids are misbehaving to that extent, and yet what are they doing about it? They're keeping them there and trying to get them back there is simply inconsistent. It's simply inconsistent, unless the people who work for Michael Jackson were motivated by two things. 1. The profit that would go along with having that family there to be able to capitalize on their statements, and their videos, and their image. And, 2, that child was needed in Michael Jackson's bedroom. There is no other explanation for it. Simply not. Now, some of these witnesses would come into court and testify to stuff, and you'd immediately say, "Who did you talk to about this? Who did you tell?" I was described as being barbaric, and, gosh, I don't even remember all the language that he called. My cross-examination of Riho Jackson, I think I was called abusive and barbaric, and one other adjective that was used to describe it, in 15 minutes of cross-examination, which is all I did. I really didn't ask him anything about what occurred in the bedroom. And I pretty much asked him only what occurred in Michael Jackson's room and what he told Michael Jackson. Virtually all of the witnesses who were asked questions about, "Okay, you saw this thing, you saw graffiti, you saw Star writing graffiti on a wall, what did you do about it? Who did you tell? Where did you note it? Where did you write it down?" None of them ever wrote any of this stuff down, ever. So let me suggest, and this is a place where they write everything down and they write it down constantly and all the time. So let me suggest to you that the absence of any kind of documentation of any of these instances should cause you pause to believe that they're probably exaggerated and some of them are probably made up. And probably the most egregious of all of that would have been Riho's testimony about the boys in a bed under the blankets and what he said was masturbation. Now, you wonder how he would know that, necessarily, if they're under the blankets. And you might wonder exactly why a 12-year-old and a 13-year-old brother would be doing such a thing in the presence of each other. And you would wonder why the two of them would do such a thing as a door would open and somebody would walk into the room and they would have no idea who that somebody would be, but they would continue doing that. That is simply not consistent with common sense. That's not consistent with your understanding as to how adolescent boys function. If it is true, then it's evidence of two boys who have been significantly sexualized. And that would be consistent with their testimony as to what took place in Michael Jackson's bedroom. In other words, his constant talking with them about masturbation, and his constant talking with them about adult sexuality, and his constant introduction to them of sexually explicit material. If you believe Riho Jackson's testimony is truthful and accurate in its entirety, then you have to ask yourself, why are these kids doing that? What is going on at Neverland? If you believe the testimony about Star walking around with explicit magazines, then you have to ask yourself, why does this child feel so uninhibited that he can do that? Because it's certainly not the child that you saw on the witness stand. And then the question of where did he get it? He did not, if it's true that he had such a magazine, he did not get it from home. He would not have said to his mother, as they were preparing to go back to Neverland from one of their trips at home, "Hold on a second while I get my copy of Hustler." That's not what a 12-year-old would say. And it's not what a 12-year-old would do. And he would not have such a thing in his back pocket as he walks around Neverland. And it wouldn't be necessary to do so, because there was plenty of that material in Michael Jackson's bedroom and they had the run of that bedroom. So you have to sit back and say, how much of this testimony is exaggeration? How much of it is just plain false? And how much of it is true? And if it's true, why is it true? Why are these boys behaving in such a fashion? And why are so many of the witnesses from Neverland saying all of the boys eventually start misbehaving? Why is that true as well? Counsel made a number of remarks about Janet Arvizo hounding celebrities for money. Calling them constantly. Hounding them for money. Causing the children to hound them for money. Now, my answer to that is, who? I mean, we dealt with all of the celebrities who were called in this particular case. None of them testified to that. And even the testimony of Jay Leno is entirely inconsistent with Mr. Mesereau's description of Jay Leno's testimony. At the beginning of this case, in his opening statement, Mr. Mesereau said that Janet was in the background telling Gavin what to say on the phone in the conversation with Mr. Leno. In his closing argument, his testimony was Janet Arvizo was in the background telling Gavin what to say in his conversation with Jay Leno. The problem was that's not what Jay Leno said. And his testimony was very different. Did you ever get any messages from anyone who claimed to be Gavin's mother? No. And then I spoke to someone else, and then I believe I spoke to the mother, who seemed very pleased that I called. Do you recall what the mother said to you? No. Very general. Thank you very much, quote, end quote. And that's the extent of it. There was never any testimony of Jay Leno whatsoever about a mother in the background trying to get her child to say things to a comedian who would then give them money. And furthermore, none of these comedians did give them money. Now, the one exception is Chris Tucker, who had a close relationship with this family, although he denies it today. He simply has taken sides in this lawsuit. That's all. But before that, he took these kids up to Oakland to go to a Raiders game. He took these kids to the Lakers Staples Center to see a Lakers game. They had Gavin's name up on the wall at some time during the halftime. Excuse me. He was sick at that time. He took them to a wedding that was in Pasadena. Today he denies that he knows anything about how they got there. That's simply not credible. That's simply not credible. That whole business about not knowing how they got to a wedding, that he didn't invite them there, and that they just somehow showed up on their own. That these kids are going to show up at a wedding in Pasadena without even knowing where it is really just not credible. But when you look at this collection of witnesses who have testified, I mean, whether it was Jamie Masada, or whether it was Louise Palanker, whether it was Jay Leno, whether it was Fritz Coleman, whether it was George Lopez, testimony about Gavin was that he was a great kid. Said, a lot like me when I was that age. And none of them say they were ever asked for money by Janet Arvizo. None of them say they ever gave money to Janet Arvizo. None of them do that. And then he comes back in his closing argument and he says, constantly calling celebrities, constantly hounding them for money. Well, when you go back in your deliberations, sit back and ask yourself, okay, which one? Which one was actually called by me? Which one was actually called by Janet Arvizo and hounded for money? That statement about DeVellin's testimony on the witness stand about what her father did to her when she was a toddler, she has no recollection of it. That statement was pretty remarkable when she testified to it in court. And you saw her reaction to it. And you saw her start crying during the course of that. She came to find out that her father had molested her when she was very small. Her father was in the room at the time, and it came out in the course of an argument between her parents. Her father acknowledged that it happened. Now, are we supposed to believe today that it didn't happen? What testimony is there today that it didn't happen? And the answer? None. The answer is none. Nobody came in. They certainly could have called David Arvizo to say it didn't happen. They didn't do that. Alcohol. There was testimony by both of the boys that they drank with Michael Jackson. There was a drinking game with Michael Jackson. It was in the presence of 2 witnesses. In the presence of Simone and in the presence of Aldo, the younger sister and younger brother of Frank Cascio. They weren't called to say it didn't happen. And both of these boys knew certainly at the time that they gave this information to law enforcement that this is information that could be contradicted by these 3 witnesses, who certainly have no loyalty to them, and have quite a loyalty to their older brother Frank, who is one of Michael Jackson's closest friends again. Why would they include the presence of witnesses who would be able to say that it didn't happen? And more significantly, why didn't they come to court to say it didn't happen? That information is not contested. DNA evidence. Let me talk to you a little bit about that, because you need to understand the extent to which this really is a red herring in this case. He says we didn't look for hairs or fibers. Hairs or fibers would reveal nothing. Fibers, they talk about. They call that trace evidence. And what they mean is it traces back to a particular source. Fibers would be things like unusual fiber from clothing found at a location, which would tend to suggest that that person had been at that location, if it's unusual fiber from clothing. We know these boys were inside that house. Everybody says they were inside that house. Fibers would lend no relevance to this case whatsoever. Not only do we know they were inside this house, but they can describe every foot of his residence. They spent the better part of 5 weeks at that residence. Hair, same thing. The presence of hair wouldn't be particularly interesting to you, because all that means is that they were in the room and they left hair behind. We already know they were in the room. DNA. DNA isn't going to be particularly interesting for you unless it's DNA from his semen. Because then what we're saying is that they ejaculated in that room, or one of them did. And now that tells us that there's sexual activity in the room, and that would be relevant, and that's what we were looking for when we took the mattress and looked to see if we could find his DNA on the mattress. Now, given his statement, what's the likelihood of that happening? His statement as to when he ejaculated, if at all, was lying on top of the bed and he was being masturbated inside his clothing, which means the ejaculation would have occurred inside his clothing. To find it on the mattress, we would have to have had a liquid seepage through his clothing, through the blankets, and through the sheets, through the mattress pad and into the mattress, 9 months earlier. In other words, that there wouldn't have been any sheets washed in 9 months. There wouldn't have been blankets changed or washed in 9 months. And in fact, it would have escaped his own clothing in that particular period of time. That is a long shot. That is a long shot. I guess the equivalent would be to say if any adult couple had sex in a hotel room, what is the likelihood that there would be DNA found from that activity 9 months later in that hotel bed? And the answer is not likely. Not likely. But we looked anyway. So the question is, does that mean that there wasn't a molestation? The answer is no. It simply means we didn't find ejaculate at that time. He either did or didn't get to that stage. Let me just say a word about Mr. Jackson's finances, because that was brought to your attention by Mr. Jackson, sick. He said that there were people who took advantage of him and that was why his finances were in trouble. No, that's not why. His finances were in trouble because he was living a much too extravagant lifestyle that he couldn't afford. He had been going on with a loss of $20 to $30 million a year that our forensic accountant was able to trace back to 1999, and likely earlier behind that, because you don't start $20 to $30 million a year deficit. He was running on a credit card, effectively, through a bank. And it was getting larger and larger and larger and larger. And as of the time of the filming of Living with Michael Jackson, he was $270 million in debt. Mortgaged, Neverland was mortgaged to the tune of $18 million, and he owed $10 million to his vendors. In other words, the people who supply services and products for Mr. Jackson and to his family, he owed them $10 million. This had nothing to do with people taking advantage of him. This had to do with him living an extravagant lifestyle that he couldn't afford. One that he could afford 20 years earlier but can't afford today and couldn't afford in 2003. And then all of a sudden, this disaster comes along. And Mr. Mesereau says all celebrities deal with public affairs disasters. They take care of it. They deal with it. They do some kind of something. They hire a PR person and everything is just fine. And the answer is, no, it doesn't really work that way. Because in this case, what he is accused of is child sexual abuse. And that is a disaster for any performer. That's not the equivalent of a disaster that includes getting caught with drugs, as many of them are. Or getting caught drunk driving, as many of them are. Or getting caught having an affair, as many of them are, which sometimes actually enhances their career. Nobody benefits from being accused of molesting a child. Nobody benefits from that. He said that there were people who were stealing from him. Mark Schaffel. Mark Schaffel is not somebody that you would want to admire. Nobody who works in the sex trade business or industry should be admired, frankly. But there's no evidence that anybody stole from Michael Jackson. And we have the accounting of all the funds that came in, and all the funds are accounted for and distributed appropriately. $2 million of that goes to an attorney by the name of Mr. Finkelstein in New York, who set up an account on behalf of Michael Jackson. That is his share of all of that. All of the other money is properly accounted for. If they had a question about it, they could have brought a forensic accountant in here to tell you that, in fact, somebody was stealing. There's no evidence that anybody was ever stealing from Michael Jackson. Not the Germans, not Mark Schaffel, not anybody else who was associated with him, Frank or Vinny. Now, with one exception. There's an inventory that you have in evidence, and that inventory of expenses that are credited to Janet Arvizo, which she says she did not incur all of that. As you look at that interview, go to the very last page of the inventory, Go to the very last page of the inventory and look at the last few dates and notations. You will find that Janet Arvizo and her family were taken out to dinner. They were taken out, there were a couple different dinners. I don't remember the restaurants at this time. But you will, as soon as you see it, you'll understand that those dinners were at a time that Janet Arvizo was in Los Angeles back with Jay, and the kids were at Neverland. In other words, they never took anybody out to dinner. So they were obviously padding the expense account on that. You'll be able to see that as soon as you look at it. That's really the only indication, a few $100s that may have gone to Vinny or Frank, that they thought would have otherwise been Mark Schaffel's. I don't think they would have stolen from Michael Jackson. Frank was very close to him and very akin to him. Did you want to take a break at this time? This would be a good time.
All right, we'll do that.